Hey,
Yeah. So we're live. Are we live?
hold on.
Yes?
I have this really cool video I want to show.
Okay. Don't be a dick. Um, anyway, J.R. Ewing or J.R. and me, not legal advice, and my Twitter, please, anybody out there who is able to follow somebody on Twitter, follow me at not legal advice. My other Twitter is still in Twitter hell, and I, what can you do? I've asked and I've done. I've complained, but whatever. So if you want to, because we're hopefully the idea here is whatever we do, hopefully is helpful, and we'd like to spread this as far and wide as we can. So if you can just follow us, both of us. What's your Twitter handle, Jr?
Widener 2004. Widener
At
2000.
okay, okay, and mine is what it says at not legal advice, one word. Currently, until I get hacked again. Anyway, we thought today, and again, to everybody out there who might be watching, or I guess I'm supposed to say this. I saw this note today. I'm supposed to say this, or to anybody out there who might watch this on replay. Hello. So if somebody in Portugal is watching this tomorrow, I say hello to you. Hello to you today. Yeah, there you go. Yeah, I've never found out. I know we have some people, at least I've seen apparently from the United Kingdom. I don't know where else. I wonder if there's anybody from Greenland. If anybody's watching
Uh,
us in Greenland, please let us know.
I know there's someone on here that it says the same thing. There it is. It's John. I'm going to butcher your last name, Curzon. He says every time. He says, "Good afternoon, Richard and Jr. from sunny California."
Yeah, and it is a very southern. It's a nice sunny day, or was
Well,
a
I got
nice
on here
sunny.
early, and I was surprised. There was like 5 people on here, and they were in the chat. I was like, "What are you people doing here?"
I don't know. I don't know. Anyway, what we kind of did, and thank you for everybody who's watching or will watch. Thank you as always. Please spread the word and share the videos. And if you think it's helpful, we appreciate that. So what we thought we were going to do, and we shall see, is we'd kind of talk about where the legal proceedings are. I have to smile when I say this. Where the legal proceedings are in GTII, kind of summarize what happened yesterday. Some of you may have seen some video of yesterday. I don't know, but I can summarize. I can
Oh my God.
summarize more of it, and then we could talk about if there's anything beyond that. There's some issues we could kind of reference, and wherever else this goes, we'd kind of try to keep this loose and light as it
Yeah,
starts.
this tonight's episode is so much different from our previous episodes where we're 110% completely prepared. We have an agenda and talking points. We didn't even do nothing tonight, which is
Yeah.
highly unlike us.
Yeah. I would say one thing, and obviously it's not legal advice, not financial advice. It's nothing. There's about two clowns talking about whatever they think. But in light of my and JR's communication with the proper parties that be, I think we're in a good position that the next time we go in front of the judge, that we'll get a positive result. That's my personal opinion. But that is not yet to be, and we'll see. That's going to be a week from Friday.
Oh my
Week
gosh.
from
I think we need to have one of the people from the chat on as a guest. Destin Al Media. Quote, I had my car stereo blasting with the Zoom call attack happened.
Yeah, I told JR to kind of keep it on the down low, and he just wouldn't listen. He wouldn't listen. I didn't
Oh
realize
my
that JR was that theatrical, but you learn something every day.
I was sitting right here looking at my screen just like this, watching the
Yeah,
attorney, and then I
you
put my face and was like,
just between you and I, notice that you can only see JR from the shoulders up. That's all. That's all I want to say. Before we get started, even though it's lighthearted, we have to start off with our jokes. Do you have any before I start?
No, I
Oh,
didn't look it up. Go ahead.
So what I'm going to do is one is it's dreadful, but I got to say it, and then luckily enough, what's good is I like people send me jokes, so I will do it. And if this person, I don't want to say their name unless they tell me I can say their name, but if they're happen to be watching or see this and they want next time, if they want to let me say their name, I'd be happy to call it out because they provided me a bunch of them that are better than mine. So let's go for it. So what SNL musical performance most resembled yesterday's hearing?
I don't know. I have no idea.
The answer is Dick in a Box.
Oh my God.
Which was a great Saturday night
Listen,
performance. That was with
I could have just said something so crude, but I thought, no, let it go. No.
Okay.
Got to stay somewhat professional.
All right. So I'll move on. I tried to come up with a carpentry pun that would work. I think I nailed it, but nobody saw it.
Everybody saw it.
This one is right on point.
Oh
by
God.
the way. I once dated a girl with a lazy eye. I always thought she was seeing someone on the side. And the irony of that particular joke is I have a lazy eye. And last but not least, a friend said she didn't understand cloning. I told her that makes two of us.
Hold on. Someone said middle ground. Two lawyers were sitting in a bar when a great looking girl walks by. Boy, no, I'm not going down that path. I'm not. We gotta.
Okay.
Yeah. Phew. Yeah.
All right. So a couple points I noticed today. I noticed the SEC abolished something and they created some other type of
I don't know.
supervisory, I'm going to call it an agency group that's supposed to protect consumers, retail. It was a lot of it was crypto. I think it was crypto related or electronic related. I didn't see anything specifically. It said, for example, we're going to try to deal with shorting, for example. But perhaps there was just maybe the language wasn't clear. But it was a clear change, and I don't know. Who knows what's going to happen if it's going to really be something's going to be constructive.
ESK's from Italy. ESK's from Italy.
Oh, nice.
Nice. Yeah.
Nice. I went to Italy before COVID and I loved it. I mean, really, I would go back in a second. So props to you out there. But one thing we haven't really talked about the deals, and I don't really want to get into too much discussion, but kind of one way I see, I'm just going to focus on, I'm not going to say it's a deal because I see it as different. I think there's one deal on the table and we all know it, and it's the AI-versity deal. There's something else that's potential, a potential, and someday might be a great deal and whatever, but I don't think it is there at this point in time. And one point in particular, I think that's relevant is I've seen the tweets, and I don't know if they're legitimate, but I think they are because I kind of followed the account of Aftermath, and they seem to dispute in some fashion the rights that TGG claims. I don't know who's right, by the way. I don't know who has between them. I don't understand who's right. But my concern is it really doesn't make a difference who's right, because if there's a dispute between them, then that's what we're getting into bed with. And who would invest into a dispute like that with not having, clear idea of the rights? So that's kind of, to me, simplifying it all down to like one little issue. That's why, to me, one day it might be great, but today it's not a deal. And so yesterday I know a bunch of you appeared by Zoom.
Well, why don't you give a brief recap? Because there was 2 comments, saying what happened with the hearing. So give a brief recap.
Oh, I was going to get to it. I was going to give you like a play-by-play. So yesterday there was a hearing in Las Vegas, downtown Las Vegas. At the hearing were the receiver, Mr. Strickland, his counsel, our counsel, Alex, myself, an attorney representing Kathy Griffin. There was an attorney representing David Reichman on Zoom, so he didn't fare very well. The Trento people were there. There was a woman, in addition to that, I think was associated with the Trento people, that wasn't introduced, so I don't know who she was, but seemed to be affiliated with that group. And then the judge and some clerk personnel. There were a few matters before us, so 2 or 3 matters. And I don't know if you guys were watching, because there was no problem in the broadcast during the first few matters, even though they were kind of boring.
Well, we most of us tuned into the employment law case that they were arguing. I watched the whole. I watched there were counterclaims too, so I don't know who the plaintiff was and who the defendant was. But I watched counsel for the employee, and then counsel for the employer had just started her argument and was maybe a minute into it when it all went south.
Yeah. So they started the calendar
up.
They kind of started the calendar. That's what they call the cases that they hear on that particular day. Around 9:15. JR is just out of control at like 9:15.
I knew this was going to happen.
So the cases got called, and so just to describe the courtroom, it was a new building. The judge was in the corner, so if you're entering the courtroom, you're kind of looking to your right but straight ahead to see the judge. And the judge probably would be, and there's a section of seats in the back of the courtroom, 2 or 3 rows. And I think 2 or 3 rows. Yeah, 3 rows of seats. And then there's like a wooden barrier, and then there's the interior of the court. So the judge, from where the seats started, the judge is probably like 45 feet maybe. And so the judge is in the corner. There's some court personnel that are there. And then to the immediate right of the judge, but in the other corner, is the screen. The screen is pretty large. I would say 10 by 10. That's kind of how it looked. And I think at one point in time, that's at least they mentioned, there were over 100 people on the Zoom. Don't know if they were all for this one particular case, but I don't think maybe 1 or 2 piped up and it was our case. So I presume that everybody was there. So we're looking at, and all the lawyers and everybody who's facing the judge is facing the screen directly.
Right.
And there's a division. So on one side are a bunch of parties and attorneys, and on the left side is another group. So I'm on the left side, and I'm speaking to various counsel. And we're kind of, trying to be quiet, not interrupt. And we're vaguely watching the proceedings. And I'm looking at I happen to be staring at that screen a lot for whatever reason. But the thing that caught my attention was the bottom half of the screen took up half the screen. So there's a bunch of boxes, and there's people like on the top row. It's like the Brady Bunch. There's like 5 on the top row, and then all of a sudden, like half this box is taken up by just taken up, and there was nothing on it. There was a name. I think it was like Mr. Whipple. I think that was the name. I'm serious. I'm serious. So. But it caught my attention because it wasn't a picture of anybody. And above that, you could see in smaller boxes pictures of somebody. So at some point in time, I don't remember. You knew what was going on in terms of what proceeding. But at some point in time, I wasn't focusing on that in particular, and I heard this like very loud noise that got my attention, and I turned to the screen, and honestly, and I think this, by the way, this happened to everybody in the courtroom because nobody made a sound. Everybody was absolutely quiet.
Oh my God.
But there was this, like, if you didn't see it, there was this extremely hardcore pornographic video that started to play in that big box on the bottom. And it may not have caught your attention, but it was so loud. I mean, the volume of the video was very loud. So you couldn't help but look. It didn't play that long. What happened was the judge had, I guess he felt that he had no alternative but to pull the plug, and he literally pulled the plug. No pun intended. He pulled the plug on Zoom, and that's when all you guys went off. So then there were, so after that, and there was discussion about that, and they said, can we trace it? And then it came out that about 6 months ago in a different courtroom in the same courthouse, there was a similar incident like that. And I guess it's not a closed system. So it's basically anybody with a link anywhere can go on or try to go on.
Well, they didn't have the Zoom muted. You should not have been able to unmute your mic. You should not have been able to take control. I don't know how that person did what they did. I don't use Zoom at work. I use Skype and Teams. So I don't know how to maneuver Zoom, but what that person did, they shouldn't have been permitted to do. The moderator.
Oh, you don't think that the person should have been able to post pornography during a court hearing?
No, they could.
Is that what you're saying?
But it was almost like they took control and were sharing their screen, not normal presenting or talking.
Everybody was pretty flustered. So I just think, the court staff, the judge, literally, I thought he turned like very pale, and the court staff kind of was, fumbling around, and everybody in the courtroom, there's like, maybe 10, 12 other people. Nobody said a word. Somebody from Trento told me, because the Trento people were there, and we were friendly, by the way. I greeted them, whatever, that their mother was watching the hearing. Yeah. So anyway, so after that,
one of those guys has some explaining to do.
Got a lot of explaining to do. So after that, then the judge, then we all appeared. Everybody introduced themselves up at the counsel table. I went up there, and our counsel introduced me and whatever. And I was babbling away because I was kind of suggesting things as we were going. It helps, by the way. It helps because I know what's going. Obviously, I've done enough litigation, but I have a better grasp of all the facts. As it turns out. So so I can be helpful and constructive in a legal sense too. So we were discussing it. The judge had made a order the prior hearing about, that they wanted all the shareholders to have an opportunity to state an objection, etc. So he felt that he could not go forward and complete it, which whatever. They originally talked about extending it for a longer period. I kind of suggested to our counsel to keep it as short as possible, and he did. So it's a week. I mean, I'd rather it be, the same day, but it's a relatively short amount of time. I had an opportunity to speak to everybody afterwards, and I think, it sounds like, and kind of what we discussed earlier, that other than Reichman's counsel, because I think Reichman will probably oppose, but other than that, I don't think anybody else is going to oppose. Now, there were some objections that the court had, like a binder that had received objections. And what I was going to talk about briefly was and a lot of people, I don't know, everybody should. I don't know if everybody does. It may go into a spam file or, whatever. But I think the receiver sent out a notice today via email. So check your email. And in the notice, which I have a part of it in front of me, it talks about how we're going to do the next hearing and how it's going to go. And, you obviously have an opportunity to attend in person if you so choose. Also, what they kind of decided is to focus more on objections. So if you have an objection, that's important. And the way they're going to do it is they're going to basically look at all the objections that have been filed and any objections that are provided, in the interim via email. Technically, all the objections are in. They were supposed to be in by the 14th. So technically, they don't have the new ones, at least the written objections, don't have to be considered. But if you have a objection and you can state it, succinctly in an email, why? Not just that you object because you'd like to know more information. Whatever your objection is, the Receivers Council will receive it, and then they will kind of collect all the objections they got, the whatever new ones they got, and they'll see if there's a common issue that they need to address. Is there something that's an issue? And if there is, at the hearing, the receiver will address that issue, and then the court will decide if there's a need for further argument. So it's going to be slightly different than kind of how we discussed before. You certainly can still participate, and in that notice, it gives you a link. I think it may be a telephonic as opposed to video. And there's an obvious reason why the video part may be excluded. In LA, by the way it works is there's an internal system that's run by the LA court, so it's not open to the public. So it could be hacked, but it's just harder to do, and you'd have an easier time to kind of figure out who was hacking. I'm sure in Vegas eventually they'll figure that out and kind of do it also, because it's pretty distracting, I would say. So I'm going to give you the email addresses, and then I'm going to post it on Twitter. I think I'm going to post it on Twitter, of who you can contact. And if you have a specific objection that you haven't already stated, you can state it to them. Try to keep it short and sweet, and try not to be, if you've already been heard, then great. Because again, like I said, the judge really did have a binder of objections. So it's not, I don't know if there was 2 in there or whatever, but they had whatever was submitted. So the email addresses that you can use to let the counsel for the receiver know if you have a specific objection, and if you don't reach out, don't bombard them, and we don't want to piss them off. If you really have an objection you don't think has been dealt with, first one is William Knoll, and his email is WNOALL at
wait, slow down. WNOALL okay,
at
yep,
GTG
yep,
GTG.legal. And the other one is,
I'll repeat back. Wait, I'm typing it in the comments.
okay.
WNNOA.
No, one too many N's.
Just one N.
Yeah. WN
WNOALL at GTG.legal.
Correct. And the other one,
that's William. That's
William Knoll. Bill. And the other one is, and this would probably be the person who would be the better contact of the two, but either is fine. You can,
never mind. It won't let me post it. Never mind.
Okay. The other one is Dylan Siciliano. I believe that's the correct pronunciation. And again, we'll post it on Twitter. DCICILIANO at GTG.legal. The same legal. DCICILIANO gtg.legal. So you could inform them of any objection. And the way it's going to work at the hearing is they're going to first deal, and this is what the notice says. So when you see the notice, you'll see what I'm talking about. That they're going to first deal with the written objections. They will ask the receiver to respond. It'll be the receiver's counsel, the receiver. If the court wants additional argument, then the court will say, can you address this? If not, then that's the end of the written objection part. Then the court might has the opportunity to permit any oral objections that may exist. And whether those exist or not, we don't know at this point in time. It kind of depends on how the hearing goes. And if there's oral objections, then those can be made, and the court can, if they're different than whatever else has been asserted, and I don't know if they'd be different, but if they are, then the court will hear. And then if the court requires further argument, then they'll let the attorneys argue about that. And that's how the hearing will go. The hearing is set for 9 o'clock. The court has a trial at 10. So this will be done before 10 o'clock. The yesterday when I was in there, they had a trial at 10:30. So they were starting a trial at 10:30. So it's not like, just kind of so you have the background, it's not like the judge is lollygagging and this is the only thing he has on to do that day. It's more like he's got like a bunch of stuff he's got to do, and this thing he wants to get it done as efficiently as possible. And again, I keep on, I'm harping on it because I don't want to turn something positive into negative, but unless, I know that everybody has their own point of view and own concerns, etc. But if you hear your concern expressed, then that's sufficient. And if you don't, then that's something you should speak up about it. But I kind of feel that it's probably going to be that there's going to be 4 or 5 concerns at most, and they're probably going to be common concerns, and we'll get some kind of answer. I don't know who else will be participating on the next hearing. The receiver did fly in from Washington, so he was there in person. But I don't know who will be participating. Anything to add, JR?
No, I mean, you were on the spot. We had, obviously you were on, just in case anybody doesn't know, we were holding a space. As soon as we got kicked out, I started a space to kind of calm people's nerves, because I assumed at that point that it was going to continue. I figured they were just, done with the Zoom and that the hearing was going to move forward. And someone had said, reach out to Richard. And I was like, look, he's got his phone off. He's in a court hearing. He's not going to pick his phone up and start texting me and live streaming. So I, had the space on and was just waiting for you to call, and you called right in the middle of the space. So, but the space, it was a good space. There was about 200 some people on there. And then, as you know, John Forrester came on. So, and he ultimately addressed some issues. So, if you still have things about the AI Versity deal, listen to that space. John comes on maybe about 40 minutes into it. And we asked him some questions, and then I really wanted other people to ask him questions. I didn't want to be the only one talking to him. So I kept telling people, take a mic. Look, the guy came on here. He's here to answer questions. Ask him questions. I already asked him questions. So yeah, for those of you that are watching that, still want to hear more information, listen to that space.
Yeah, and he's made himself available. The Trento people made themselves available too. So it's not to say that they haven't, and they were there. So I'll give them that.
Yeah, and they held a space on Sunday or Saturday, but they held a couple of different spaces. So there's information out there for anybody that wants it. There were a couple of questions.
Sure.
The big question that I continue to see, and I saw it a couple of times on Twitter, people want to know when it's going to trade again. But I think people need to take a step back. Just because this deal is getting done does not turn the trading button back on. And if you listen to what John Forrester was saying yesterday, let's assume a deal gets approved, whether it's John or pretend deal. If a deal gets approved, we're still on 2 tracks. we're on the new track with the new corporation, and the receiver is still on his track. And the receiver has to finish his work, which is finishing the financials, finishing the audit, finishing all the clawbacks that he can finish. So those things need to happen probably before it starts trading, and when it does start trading, it's going to be the receiver does the bulk of the work, and then there'll be some conjunction with the new corporation, and then it'll be listed back on the OTC.
Yeah.
So this is not a light switch, folks. The light switch is not going to be flipped on this deal, and then the next day it's going to be back on the market. That doesn't happen.
Yeah, and I would say, like, the way I would look at it is until you hear that the audit's been signed off and done, it's the timing is irrelevant because it ain't going to happen before that. And kind of let me kind of update you a little bit about that. It's ongoing. The preparation is ongoing. The receiver has found somebody to do it. I guess the issue, and it was expressed before, and according to the receiver in one of his reports, so Borgers was that original CPA that sucked. They got basically excoriated. It was like one of our videos. They got excoriated by the SEC and out of business. Then the prior management went to another CPA firm, a small firm out in Orange County, California. I don't know how they found that particular firm. That firm was working, and then obviously there was the receiver took over. The receiver, according to reports, tried to work with that particular CPA. They couldn't get certain information they needed to get, and they thought that the CPA was not being helpful in completing the task. I have a problem with that, by the way. I think the CPA has a fiduciary duty to all of us. So, on the bottom of our list of things to do, there's one, why the CPA is not being cooperative. But the receiver found somebody else. The information that was needed, amongst the information that was needed, was some information from Justine Reichman, and they needed financial information. And apparently, and I don't know if there's other information they need, but they apparently needed some financial information related to Dot 8. And if you look at the reports, if you go back and you look at the receiver's reports, you'll see Dot 8 prominently listed as either it received a bunch of money or a bunch of shares. I don't remember which one, but it wasn't just like a shell with nothing. There was contents to it. So I guess there was an attempt to informally get information. I wasn't involved, so I'm just kind of like, this is my view of it, even though I don't know it firsthand. But I think there was an informal attempt or attempts to get the information. Didn't work. Then there was some motion filed in court to seek a contempt order against them because they didn't comply with the subpoena. Before the hearing, there was an agreement reached, apparently. And my understanding is that Justine or somebody associated with Dot 8, because I don't know, because it's really Dot 8, will provide the documentation, and that there will be a deposition of whoever is the person most knowledgeable at Dot 8 as to these documents. Then, hopefully, after that information is obtained, then the auditor can use that to complete the audit. That's my hope and understanding. And I'm hoping that occurs by the end of March, but I don't know because it depends on how long it takes to get all the information.
So Mark Maddox has a question, and Mark, we'll briefly address it, but I'm going to encourage you to go listen to that space that I just talked about because John Forrester answers this question specifically. It's about the preferred series B.
Yeah. So I can explain that really, and it's not something we knew or that we understood. How about like understood? Maybe we could have known it, but we didn't understood. At some point in time, my understanding is that David Reichman issued himself Class A preferred shares that had super voting rights, and that, but for having a new class of shares that could outvote that particular Class A, nobody would do a deal. So right. I guess amongst I wasn't involved in discussions, by the way, but amongst counsel, they decided the best way to do it would be this way, to set up a new class of shares that would be able to outvote them. I think John talked about that once that is taken care of, he would be open to kind of modifying that arrangement. But I don't think it had anything to do. specifically with a monetary advantage, because you have to understand the difference. And this is a difference. And, it could be good or bad, but it is what it is. The way the agreement is with AIversity, they're just getting voting control. There is no monetary, they get nothing monetarily at this point in time.
Right.
The other, I'm going to call it future deal, that's kind of how I see it. The 30 million shares were getting paid out upon execution, period. That's it. And so the only thing about that transaction was the monetary part. So I see that as different. And the fact that he wasn't taking a monetary advantage, I thought was positive. Of course, ultimately, we have to trust and scrutinize. And I would say anybody who's going to be doing business in our sphere, JR and I, especially as the GTII, they would be smart enough to consider that if there's any future shenanigans going on, that we will call it out as we've done in the past. So that gives me comfort also that somebody coming in the space will be on the up and up, because they know that if they're not, we're going to call them out for it.
Right. So Mark, the Series B preferred shares are to make sure that Forrester's team, Forrester and his board doesn't lose voting control of their company because of these Series A shares that are Series preferred A shares that are already out there and in Reichman's control. I get it. They need to do that.
Yeah, and
but I would encourage you to listen to that space to hear it right from John Forrester's own mouth. Again, it's on the space. We addressed that issue, and we addressed the $4 million liquidation clause issue, which he pretty much committed to. Look, once everything's done and we know what we're getting into, we likely can get rid of that provision, and they're using that as an insurance policy for their own investors. So, but go out and listen to the space, because I'd rather you hear it from him than us paraphrasing it. He comes on about halfway through, and he is there pretty much till the end.
And I don't know, how it's ultimately going to end up, whatever, I don't know how the business is going to end up. No idea. I'm excited about it, but I have no idea how it's going to go up. But I also don't know specifically how the case is going to end. But I wouldn't, but there's been discussion about those Class A shares and the validity. And I would not be shocked, but I would kind of expect that in the end, that those Class A shares would not exist. That's just my expectation at some future point. Not legal advice, not a guarantee, but I think.
Well, I would agree with that. But if you think about, what are we concerned with as shareholders? What rights don't we want to lose? And we question John on this. We don't want to be forced into a reverse split. We don't want to be forced into hundreds of millions of shares being issued. We want to get away from what Reichman was doing. And I don't think you and I emphasize this enough, and we should have. We already don't have control of this company. When Reichman was a CEO, we had no say over anything. Reichman could have done a reverse split anytime he wanted to, and he could have done a share issuance anytime.
He could even secretly have issued himself Series A preferred super voting,
which is exactly what he did. So this notion that we're giving up control of our company, we've never had control of the company. And shame on Richard and I for not expressing that enough. But we point blank asked Forrester on the call or on our live stream and basically said, we're not talking about taking control of your company. We don't need to be the directional people. We want control over whether or not a reverse split is going to happen. We want control. We want voting rights over whether or not new shares are going to be issued. And we want to know reasons why. We want you to talk to us about it. And he committed. He said, look, once we get things done and get settled in and get all this other shit straightened out, he was definitely open to creating true bylaws and giving some of the power back to the shareholders that we should have had all along.
Yeah, and again, I'm kind of a cynic, so I don't know how it's going to work out, but it seems like under the circumstances, because again, this is not like we have the greatest. This is not where like Tesla finding suitors and they're knocking down the doors. This and the other part, and this applies to everything, is, and we don't know, but most of us feel there's an SEC clock ticking. And at some point in time, the SEC clock's going to strike midnight, and GTII will be no longer.
Yeah,
and
I agree. I mean, there's definitely a sense of urgency, no doubt. But someone else had another question that we.
by the way, and I hope you guys know this. If we thought it was a shitty deal, we'd tell you. I mean, we really would. And obviously,
Absolutely.
when we first heard about it, we were very skeptical, to say the least.
Well, we were. You and I were both all over the series
Yep.
preferred shares. That was our biggest concern. I mean, I remember sitting here in the conversation. What the fuck? What is this? And why do we need this?
Yeah.
But you and I weren't connecting the dots. If we'd have talked through it a little bit more, but again, that all happened in what 4 or 5 hours, and we're throwing together. We really need to be more prepared for these shows. But as soon as he said it, it makes perfect sense, and he's right. We didn't have control anyways. I mean, look at what Reichman was doing the whole time. So yeah, I get it, but yeah, I want to have a discussion. When things get settled down, do we really need those? So, but there was another question out there. Where did it go? Oh, did the trustee ever ask for the blue sheets data as part of the bankruptcy to figure out the real share count? So a couple of things to that. Number one, we're not in bankruptcy. We're in receivership. We have assets, but we don't have much, but we don't really have liabilities. So there really isn't a bankruptcy. It's more along the lines of if we go to shit, it's just going to be complete liquidation. Okay. The other thing too is, and I think you and I need to address this. There's still this emphasis on the short position, and Alpine, and Alpine, and Alpine. The receiver's job is to get the company functional. The receiver's job is not to investigate naked short selling. The receiver's job is not to go after Alpine. That stuff's not going to happen, folks. It's just not going to happen. That's not the receiver's role. Okay. So the other thing is Alpine is still alive. They're still kicking right now. Their hearing or their legal state is they won on one issue, which was the non-delegation clause in the appellate court, but they appealed the other issues that they lost at that court to the full panel. And so while that non-delegation clause was sent back to the trial court, all of those other issues went up to the full appellate court. The trial court is sitting on that non-delegation clause, waiting for a decision to be made on these other constitutional legal issues. So they're in legal purgatory right now, waiting on the appellate court to address those issues. That's where the court case is at.
Yeah, and my view, by the way, on Alpine is my view always has been I have no idea, other than that one page that says there's a concentrated short position in Alpine, which, okay, there was at one point in time. I have no idea if that exists as of today and what you can do to show it up. Although John said, John expressed interest, John Bing of AI Versity, he expressed interest in those areas. But I do know that if in fact there is a concentrated short position, especially if there's a concentrated short position that's not legitimate, that if the business does gangbusters, that somebody's going to have to cover a position. And that would be without disclosing getting a share count. I know that the receiver said he did contact all the agents and get a share count, but I don't think he's able, the same issues about the ability to have access to the records. And as I maintain, all SROs should lack immunity. That's one thing, by the way, I'm going to suggest to John, if in fact that his company ends up being being successful, that if in fact he has contacts in the right places, that removing immunity I think it makes sense. By the way, with DOGE, the current DOGE, getting rid of like SROs is probably appropriate. There may not be any reason for SROs like FINRA, or more my point, if you can't get it to that point in time, just remove their immunity.
So Mark, I see your questions. I'm gonna tell you, go back and listen to that space. Okay, listen to the space. Fast forward to 40 minutes, because it's one of the very first questions that I addressed with John Forrester when he came on. Each holder of those preferred series shares does not get $4 million if the company is dissolved. The $4 million is an insurance policy in case things go to shit based on what the receiver continues to find after the deal is made. They don't want to lose the money that they're putting into this deal, and I can appreciate that. They're a private entity with private investors. If you were a private investor and John Forrester is the CEO of the company that you invested in privately, is making this deal, knowing it's in receivership, you're going to want some assurance you're not going to lose your investment on that end. That's what that $4 million represents. Okay. It's not a money grab for $4 million. It's an insurance policy. But I would encourage you to go listen to him say those things, because we didn't get to question him on the live stream about the $4 million liquidation clause because we spent so much time on the preferred series B shares. Again, Mark, those shares are to maintain voting control because Reichman gave himself Series A shares that had voting control over the common shares. So in order to counter that, the receiver suggested you create these Series B shares so that you override Reichman's supermajority. That's what it's for. But go listen to it. Go listen.
Yeah. Again, and it's not in any agreement, but I think also in the spaces he said that this is John, and I'm not, I don't remember the precise language, but it was to the effect that once the deal closes, he's willing to either remove or reconsider that provision. And I understand it is 4 million total. There's not 4 million existing anyway. Yeah.
Right.
But again, he's been open and he said to call him out, call him out, keep him in check. And we intend to. He seems to be, again.
Well, here's what I'm going to say. When he was on the show, and I pinged him on this, and I said to him yesterday, look, we're going to hold your feet to the fire. And he's like, absolutely, I understand. But he came on the show by himself. Like I had no expectation that he came on. Quite frankly, I didn't even think about inviting him, but I didn't think about inviting anybody. I was just trying to give an update on what I thought was going on because I knew their nerves were all going to be all over the place when we couldn't get back in. So, and then 40 minutes into it, somebody's pinging me and saying, "Hey, Forrester's on there," and so I'm frantically scrolling down, and then I see him, but by the time I saw him, busy had already given him a mic. So yeah, look, go listen to that call. I'd rather you hear it from him than me. So.
Yeah. And the way I look at it otherwise, and again, I have no idea if the business is going to work, but if somebody has a business and they cater to retail traders, and should they screw those retail traders, it probably would not be very good for their business.
No, so, I mean, look, you and I are the perfect example. We're going to fucking tear him a new asshole if he screws us over. I mean, we're part of the MMTLP community. I've already talked to the guys a bunch of times in the Bobby community and GME communities. He's not a dummy. So
yeah. Oh yeah, no, I think this company, besides helping GTII, if it goes well, it could be the beacon for retail. All us retailers, because it's probably not. I don't think Goldman owns a lot of GTII. That's just my guess. Yeah, I part of this excitement is that it kind of gives a voice, hopefully gives a voice for retail. And it's not, the difference is we have a way of impacting that. And most times we don't. I remember the guy from Genius, Hamilton, was that guy's Hamilton? All that. Yeah. All that stuff that didn't seem to go anywhere, period. And then they seem to kind of disappear. So you never know, but this guy seems to be on, sharp, ready to go. And again, timing is important here. If the Trento deal, if they had all the contracts done and signed and everything, they had a bank with a loan commitment, and they had a signed agreement with the mining company themselves, and it was today, then that's kind of a different story. And again, my view is, and I think John even said this, when he'd welcome them when they have a deal that's ready to go, approach them. He said he'd be willing to approach him. Why wouldn't, if the deal as portrayed is the benefits GTII, why wouldn't it be considered? Even, notwithstanding the issues we have potentially about valuation, maybe.
Yeah.
Yeah.
Richie Rich. No, it's not the former president. I think he was the CFO, Eric Swidel.
Yeah. I
think
don't
he
know
was.
if there's going to be other, there may be other additions down the line too. I don't know.
All right.
Yeah. Maybe they'll
So
have
another.
like, I'm waiting for, I think this would be a great idea. So I'm suggesting it. I think it'd be a great idea for some companies to have a designated non-voting position on the board that speaks for retail. Period. So we're not excluded completely from decision making, even if we can't vote. But it'd be nice to be on the inside and have a representative on the inside.
Well, I think that I think something like that makes sense for company, that's. I think that makes sense for a company like AI-versity that's trying to go public and is focused on retail investors, or a brokerage company that's focused on retail investors. Does something like that make sense for, Apple? I don't know.
No. Yeah. Yeah. I don't know if it makes sense for anybody, to be honest, but it was just, idea I had. I thought it would be a way of, attracting retail support, if nothing else. And to this point in time, I don't think anybody in retail feels like they have kind of any
A
particular
voice.
power. I don't think they do.
Well, no, I mean, but that's why we all gathered on X. I mean,
Yeah.
that's, it's amazing to me. And you and I talked about this very early, and I've said this 1,000 times. What happened on X with MMTLP was grassroots, civil action. It was grassroots, lobbying. It was grassroots everything. It's very similar to this what the civil rights movement was. All that was word of mouth back in the '60s, and all of it was word of mouth in 2023 with MMTLP and X. It's amazing to me. Someone did ask here why we don't have any more MMTLP comment or content. Um, I'm going to be on a junk space tomorrow morning because she wanted me to talk about the Next Bridge press release. I don't necessarily think that we intentionally stopped talking about MMTLP. I know me personally, I'm not involved in the congressional push to the extent that I had been. In fact, I'm not even doing anything with Congress at this point. I have been focused on some of the legal court stuff that's been going on with MMTLP in the background. I'm not doing congressional calls. I'm not on the space at MMTL morning spaces like I was because I have work to do. That's really the only reason. But I do talk to Curtis on the regular. I talk to Notoriety every couple of weeks, and I talk to Junk probably every 4 or 5 days or so. But she had asked me to come on a space tomorrow and talk about the press release and the Administrative Procedures Act. So I intend to do that.
Yeah, I generally follow it. Generally, I don't have. If I have something to add, I'll communicate it. Usually, probably to JR, and I figure, and this kind of took time, but as we kind of went through the process we're going through right now, I kind of have hope that through GTII, maybe that will open a door up for MMTLP. That's kind of that if GTII, because I personally tried legal routes, sued all the clowns, then we went to arbitration. So I tried all that. So now we're trying kind of a different approach. I wasn't really doing it for that reason, but as we got through GTI and as we get to the point now, and as we got to somebody who seemed to have an interest in retail traders and certain contacts that might have significance, I thought, wow, wouldn't it be great if through the door of GTII we could be impactful to all retail shareholders of getting screwed.
Right.
And I know John knows about MMTLP. I know because
Yeah. Well, we know that.
Yeah.
Well, the other thing here though too is there are folks in the MMTLP community that are knee deep in this stuff, and I mean knee deep. And I know Curtis and Notoriety and Drew. I know Drew posted something today that he had some meeting, and these guys are on it, and these guys are sharp. They know the facts, they know the law, and they are connected to the people in Congress and on some of these other, committees. I mean, I don't know what else to say other than they're doing a fantastic job, and I don't need to inject myself in there. Curtis said to me the other day, jokingly, of course, he's like, JR, you're not the only big brain in the room. And then he called me a shill. So yeah, there's no need for me. I mean, maybe we should have Curtis on here one night, or Drew or Notoriety, one of those guys, so that they can talk.
Sure.
But those guys are just doing a fantastic job. I went down to Pulte's event. It was an opportunity to go, and it's just easy to get to, so I went. But I am admittedly not in the thick of things where like I had been a year and a half ago.
Yeah, and for me again, if I can't be helpful, then I'm gonna be quiet about it.
It's not that I'm not being helpful or not kind of being involved.
Yes, you are. You're very unhelpful.
But I'm just not in the congressional push like I was. But I am working on something, and when someone calls and needs something, I'm always happy to talk. And I know Junk calls me a bit to run things by me, and all those folks, Junk, Jen Capella, Notoriety, Curtis, Drew, all of those people, they know what they're doing. I don't feel like I need to inject myself into what's going on now. It's just muddy the waters.
I think they're hoping the new administration kind of has a different view.
Oh, they absolutely, we absolutely are. We absolutely are.
Yeah. And that's kind of their hope. And again, it appears there may be some crossover in people between GTI, whoever you'd want to speak to related to GTI and maybe related to MMTLP. So anyway, I'm hoping that I'm hoping obviously for GTII people that this closes and that it works great and we all can have a big party somewhere at some point in time. Maybe the Big Easy, because we had a conversation about that yesterday in New Orleans.
Mark is driving down there for
the Mardi Gras, right? Yeah, so maybe we could do it there. But we haven't forgot about MMTLP because we're in it and we spent a ton of time on it. And again, we might require a more generalized solution that impacts all these companies, and that's what I'm hoping for.
Here's a good question from Brett. Does DOGE have the right to audit FINRA considering they are a non-taxpayer funded SRO, or will it be the SEC's job? Will it be the SEC's job to audit FINRA considering and that being mandated by the SEC, or question?
Yeah, I would say probably DOGE would say we have the right to audit you, and you could either get audited or cease being a contracted party to the government.
Right. I mean, I don't see there being any issue for DOGE going in and auditing them. I mean, they just put out the executive order about all of these different commissions. So, it's clear that Trump is reining in the administrative bodies, whether they're, full-blown agencies, whether they're commissions, or whether they're self-regulatory organizations. Yeah. Just because these organizations, while yes, they are private, they're private because that's what the statute says they are. They're a private entity of certain members, and they gain their authority from a statutory provision in the Securities and Exchange Act. So I would make the argument, and I'm sure the Trump administration is doing the same thing, that we have every right to go in there.
I would be interested to see, because I presume there must be some contract, because again, FINRA is private. So I presume there must be some contract between the SEC and FINRA that describes what their obligations are, et cetera. And if there is such a contract, it also probably talks about auditing rights and things like that. so it may be laid out in some agreement. If not, then there may be a dispute. And, very likely, if you could look at it one of two ways. Some agencies, some people don't want to be audited, period. And it may just be they don't want to be audited. It may not be they have anything to hide. It may just be they don't want somebody to have access to their confidential information. On the other hand, sometimes people got skeletons and don't want to disclose that, and that's the reason why they're doing that. FINRA, I don't know. FINRA again. And I've been like yelling about this for quite some time. I think removing their immunity kind of solves everything in my mind.
That's what I was just going to say. Look, FINRA can make the argument that DOGE can't come in and audit, but the administration has all the leverage. Okay, FINRA, you're making an argument that we can't come in and audit you. Well, guess what? We're going to throw a quick bill together that absolves you of all your immunity.
Yeah. Or
It can be done.
Yeah. And the alternative is you can just terminate them.
Yeah.
It's probably if there's a contract, there's probably some provision that somebody could argue that this gives us the power to terminate you because you haven't complied. And again, especially if there's a specific audit provision, and I don't know if they're going to find anything, so I don't know. But the difference would be, and this is all guess, but maybe like the audits that are done in general by government for government, maybe they aren't like super careful and super well done. So maybe there's not as much of a risk for being exposed for, just mistakes. It doesn't have to be intentional. But I think with the DOGE crew, good or bad, I think Elon mentioned this, that he had a bunch of really sharp people on his staff, and they probably are not going to be, they're going to be super critical and make, I guess if they're looking over your shoulder, you're going to have to answer, and it's probably not going to be pleasant. So you're probably going to get a lot of opposition. So yes, I expect, I think it'd be a good idea to audit FINRA and see what they're doing and what they have done. I think they should audit the SEC to see how they've handled their actions, because I think what's not included, so the SEC is obligated to do a bunch of stuff to protect the market. They may not. So is that it? No, because there may be like huge damage to private individuals that's really not factored into that consideration of like saving money for the government. But if you acted upon it, maybe you're saving money for investors directly. So I'd be for it. I understand if I was like, my guess, if I had something like FINRA and somebody was going to come and audit me, I would not like that. And it would be a ton of work and time, but it still might be the best thing to do. Any more questions?
I'm reading through them. Someone said it's Section 19H of the Exchange Act, which allows the SEC to censure, suspend, or revoke the registration of an SRO for such failures. Yeah, there's no question that they have the authority, and if they make the argument that they don't, they're just going to rip them of their status. And if they rip them of their status, guess what goes away?
Yeah, I guess the issue would be I think I did a video. No, I did it on Farzad's channel when DOGE was being formed. The issue is the way regulatory bodies are set up. There needs to be approval from Congress. DOGE did not have that. So all these lawsuits basically are questioning the authority of DOGE because is it a regulatory body or is it something else? Originally also it was going to have a different component of who was going to be running it. And, I guess people are arguing they don't have a real understanding of what's going on. That's kind of I guess it would be like the Trento argument. We really don't understand what's going on.
So I would make this argument, though. I would make the argument that the president has the authority to hire his team. We know that. And if they're hiring his team, that team has the authority to go into any agency and do anything. There's no question about that. It's the executive branch.
Yeah.
Congress can bitch up and down all they want, but at the end of the day, it's part of the executive branch. And to me, it's a simple checks and balances argument.
Well, does it invoke the non-delegation issue though? So by delegating the responsibility of the audit from Congress to some group, doesn't now the president have to actively sign off on every removal of because I've heard him in a speech talk about, we found these items X, Y, and Z. At some point, they're going to stop those items. Does the president have to carefully scrutinize the actions of some body to comply with the constitutional protections? I don't know, by the way, but I think it will be raised. And I don't know how the Supreme Court will rule, and it may be moot at that point in time. Because, for example, if a agency shut down, people decide to leave, they're probably not going to come back 3 years later.
Yeah, I don't think the president can shut an agency down. That's going to
it can. I guess they're trying to. There were people that have probationary status that you might be able to, not bring on board. There's probably people that are retiring and you don't have to rehire. There's probably a lot of that you can do. And you give. I know they've given out a lot of offers to retire early, and then they'll pay you for like 6 months, and then you could take a hike, and there'll be a bunch of those people. Anyway, go ahead. I'm sorry.
But we're in the problem we're in right now with these regulatory agencies because all the previous administrations, and I'm going to call them out: Biden, Obama, the first Trump administration, Bush, Bush Jr., Bush Sr., all the way back to Reagan. Okay, so now you have Reagan had his hands all over these administrative agencies. Now you go 40 years through one Trump administration, but now you're at the second Trump administration, and they're doing something very similar to what Reagan did. They are taking a microscope to these agencies. The difference between what Trump did and what Reagan did is these agencies have grown 10x since Reagan was in office, and there's more authority and more regulations and more bullshit. So you've had 40 years of administrations ignoring what's been going on in these administrations, which is why they're captured. So, I'm not sympathetic to any of these people in these agencies, especially after what we've all been through in the last 3 years in the markets. Fuck them. Let Trump go in there. Let them put them under a microscope. It's time, But we've got some questions.
Well, hold on a second before you go to that question. So my view on that would be slightly different. I'm fine, and I think there's too much fat in government. I think government sucks. As opposed to the last 40 years, I would extend it slightly. I would say the last 249 years, government has sucked. I honestly do. I mean, and again, I'm sure it's very hard to manage a country. And maybe we do it best of all, but still could suck.
Sure.
So I'm hoping that changes in the future. But what I think of it as more like the stock market. So like a stock gets some news and it goes crazy. It goes way past what it should. And then it gets some negative news and it goes crazy. And it goes way past where it should go on the downside. So the way I see it, and this is my expectation, that to the extent DOGE makes cuts, they'll probably overcut. And at some future point in time, as to some services that we all need, that we may not be thinking about today, that's buried in some program, that there will be, maybe we shouldn't have quite have gone that far on some particular issues. And part of it is I don't think it's something that we can understand. Honestly, I think it's too big. The task is huge, and to be able to understand precisely what's going on, I think it's beyond me. It's like me watching that video in the courtroom. As stunned as I was, so stunned, I just couldn't comprehend it. I think the problem and the information is so vast that we really can't appreciate what it is. I appreciate the fact that they save money. I just again I don't trust government, and then my expectation is they'll F it up this time too.
Yeah, I mean, look, the pendulum has just come to the other side of the.
Yeah. You said you had a
Okay.
couple questions?
Yeah, Brett, my biggest question is who can get these blue sheets in their hands? Does it need to go through Congress or can a DOGE get them? Well, we don't know if DOGE can get them. We don't know. We know
My guess,
Congress can get them, and
yeah.
they've just chosen not to up to this point. Can DOGE get them? I mean, I can make an argument that they should be able to get them, but I don't know the answer to that.
Yeah, I don't think DOGE has subpoena power. See, that's a problem, right? So if it was a regulatory body, it would have subpoena power and they could just subpoena the records. I don't think they have them. Maybe they could get somebody in Congress
Well,
to do it.
I
They
think
they could
someone in
probably
the
get,
White House could tell the SEC we want the blue sheets,
they
and
could, but
the
they're
SEC
not
could
obligated.
get them.
They're not obligated to comply. That once a subpoena went out, they would be. And
How
the
can they
guy,
not be but see, that's a problem for me. How can the SEC not be obligated to comply if someone from the White House is saying, give us this information?
I think I don't know who has the right to. I don't know. I don't know if that's Congress that has the obligation to ask for that, or I don't know if the president is. Perhaps they, because either way, right? The Republicans in Congress, if they have the right in Congress to ask for that, well, we know it, right?
We know they have the right.
In the MMTLP situation, there was no time where any congressman, as far as I know, who was approached, even though I wasn't the one doing the approaching, and I know GR was, and there was a ton of people that I know spent a ton of time, but there was no response. I never saw it that said the Congress couldn't get the blue sheets. They elected not to. They elected not to subpoena the records. So I don't think it's on the White House to do it. I think that's a Congress to do it. Congress has had this. If anybody understands the issue, it's Congress, because they were approached on MMTLP already. The groundwork's laid. The president, whether he wants to act or not, he doesn't have the background in that because he hasn't been like for the last 3 years, people calling him up.
Right, but I no, you're not wrong. But I think the question is for me, I think the administration has the authority to get anything that they need to get out of these agencies. There should be, they don't need to, if they need to file a subpoena against an agency for an agency not complying with a data request, that's a problem for me.
Well,
okay, that's no longer an agency. That's a rogue department of the government, as far as I'm concerned.
I'm sure it can be, they can obtain the documents if it's refused. But what I'm saying is that Congress has been in a position and can, because we know they can, because they haven't said they can't, and they haven't. And I would think, especially with a friendlier SEC chairman, and that might have more success than in the past. Again, we've never had this before, right? We've never had DOGE. We've never had like a agency, non-agency interacting with government. We don't know how the courts are ultimately going to decide. So we're kind of just like everything else we talk about. We're speculating about what may happen.
Right.
Yeah. And that's notwithstanding what would be good, best for the country or, worse for the country. Just that a lot of times it's going to be, notwithstanding how we like it, it's going to be procedure and the appropriate ways of pursuing things that's going to be the key thing. And when I find this humorous, when people say, for example, that somebody got off on a technicality, I kind of laugh to myself. And I think, this is what I think in my small little head up here. I think the law is all technicalities. That's what it is. That's what law is. So to say that somebody got off on a technicality, that is what the law is. We may not like it. Yes, sir.
I was going to say that hearing got off on a technicality.
It did. Again, I told JR to kind of keep it down, but he wasn't willing to do it. What can you do? Any other questions?
When is a reasonable expectation for GTII to begin trading again, assuming things go well? Hawkeye, I'm going to answer this question again just because it's you and you're always on here. We don't know the answer to that question. Let's assume the deal is consummated with AIversity. What's going to happen is there's going to be two paths. There's going to be the new company, AIversity, GTI, whatever you want to call it. And then the receiver is still going to be doing his work. The receiver is going to be responsible for completing the audits and getting all the things necessary, all the filings necessary with both the SEC and the OTC markets to get it relisted on the OTC. The short answer is we don't know. We don't know what the time frame is for that. We don't know how long it's going to take. I know it's just speculation, but do you think MMTLP will end up in a forced settlement? I don't know, man. I really don't know. You know, that's a better question for Curtis, the Drew, and the Notoriety and the Jump.
Do you want to give us a preview?
Deeper in it.
Do you want to give us a preview? Because there was a recent filing, right? Or a suggested filing?
It was so NextBridge put out a press release, and I read it the other day. It talks about the gist of what I got out of the press release is they hired Christian Adler, which is Wes Christian's law firm, and they're going to start prosecuting some of the people that have been slanderous on X. So they're going after some of these people that have just run their mouths and run their mouths and run their mouths. And they were looking at claims under the Administrative Procedures Act. Now, I know you're probably rolling your eyes, right? Because you've been hearing about the Administrative Procedures Act for about 2.5 years now. So under the Administrative Procedures Act, when an agency makes a decision that's harmful, you have a cause of action under the Administrative Procedures Act. It's 17 or 702 Section A or Section B or one of those sections. And it basically says, look, when the agency makes a decision that's arbitrary and capricious or not in accordance with the law, those are your causes of action. So you file claims based on the decision. Was the decision made arbitrarily and capriciously, or was the decision not in accordance with existing law? And so when you and I'll go back. You and I have been bouncing around the Administrative Procedures Act for 2.5 years now. But the big hurdle to always get over with the Administrative Procedures Act was the Chevron doctrine. The Chevron doctrine basically says that if an agency makes a decision and that decision is based on the law and the law is clear and concise, that's it. The analysis is over and the agency had the authority to make the decision that they made. Okay? But when the law isn't crystal clear and it's vague, then the agency is shown deference by the court, meaning the court looks at the decision, the agency gives their reasoning for making the decision, and the court says, yep, that's it. We agree with you. That's reasonable. Mr. Defendant, you now have to prove that that decision is unreasonable. And proving a decision of an agency is unreasonable is a huge hurdle to get over. It's just that simple. Now, that was all the way up until last summer when a case came down from the Supreme Court called Loper-Bright. And what Loper-Bright says was, no, Chevron doctrine was wrong. Chevron doctrine took the authority of Article III courts' power to review agency decisions away. It's a court's job to review the decision, interpret the law, and apply, what the law is. So Chevron has been taking the authority of the courts away. So what Loper-Bright said was, no, Chevron's gone. You no longer have to show them deference. Now, the court, the federal district court, the appellate court, and the Supreme Court has the right to review the decision that was made, whether it was reasonable or not. So the threshold now is the hurdle went from a 110 high hurdle to, a broom handle to get over. The agency can scream up and down that their decision was reasonable, but it doesn't matter the reason why. The court now has the authority to review the decision, and the court has the authority to make the decision to say, no, agency, that was the wrong decision. You should have done X, Y, and Z. So Loper-Bright, and I don't think people realize how important that Supreme Court decision was, because Chevron was the law of the land for 50 years. Even going back before Chevron was codified in case law, that's what the Article III courts had been doing, showing the agency's deference. And when Chevron finally got to the Supreme Court, they basically said, look, this is what we've been doing, so we're going to codify it. Here's the analysis. Loper-Bright wiped out Chevron. So you basically just changed the next 30, 40, 50 years of administrative law and how these agency decisions are reviewed.
Wow. How boring that was.
I love it.
I know you and
I can talk
I
hours.
make jokes. I make jokes to JR probably daily about the Administrative Procedures Act.
Look,
I've probably made that joke to him like 50 times. What was the question?
there was no question. You asked me to talk.
You know,
you asked me to
JR,
talk about
I didn't follow everything. Could you repeat everything after JR? Could you please tell us?
So that's what I'm going to talk about tomorrow. So I think, there was a lot of, Greg's not on our side and Greg's not doing this and Greg's not doing that. And that none of that was true. I mean, Greg, you got to take, this, I'm going to talk to the audience. CEOs, they got to take a step back. They got to look for a multitude of things before they make a decision. And Greg has been waiting and waiting and waiting and waiting for his S1 to get approved. And the S1 hasn't been approved. Now, I'm just speculating. I have no insider knowledge. I'm just telling you what I'm thinking. So I'm not surprised that they're now reviewing, okay, what can we do under the Administrative Procedures Act? What can we do against the SEC? Because once they go to bat with the SEC, that S1 is going to be on hold forever. And that's the reality, but that's where the regulator is captured. Because in reality, this S1 should have been approved when, soon after it was submitted.
So that's what you're going to be discussing tomorrow?
Yeah.
And
I think that's what she wants me to talk about.
Where could they find that if they're looking for it?
It's junk savvy space.
MMTLP on Spaces.
Yeah, I think she starts between 8:30 and 9. I just told her I'd pop on sometime first thing in the morning. Yeah.
Have you been watching the series? Have you watched the series Severance?
No. I don't watch TV.
Well, this is on, I can't tell you what network it's on, either on Apple or Netflix. I don't know which one. Might be Apple. Apple TV.
I surf Twitter all night and watch our reruns.
I think it's an interesting series.
No, I haven't seen it.
Okay. Well, then I can't talk about it. Can I talk about it and disclose what's happening, or is that?
I don't care. I don't care, but you might piss off other viewers.
I can give you the premise. I give you the premise of it because this is, everybody knows about this part. The premise is that these people go to work at this particular facility, and once they get in the facility, they don't remember their identity. So they become a different identity in the business. And when they leave at night, they go back to the prior identity and they don't remember the day in the facility. And that's the setup of the series. And it's pretty interesting so far. Season 2.
I recommend that. I watched a rerun of Star Trek Next Generation. That's how bored I was.
There you go.
Brett, it's just Jump's normal morning space. It's not anything special. She just asked me to come on, and I told her, she asked me at the beginning of the week when the press release came out. And I told her not until we got through Wednesday because I was hyper-focused on GTII. And so I told her that I would come on Thursday, and then she said, well, I'm not having my space on Thursday. And I said, okay, what does Friday look like? And she said, Friday's fine. So I will pop on her space tomorrow. Oh, hey, Rich, better JR and all. Nice. I'm finally getting a little respect out of Big JR.
I like that. Nice to have him. Nice to have him on board, and I like his. And he was on our show once.
Yeah, he was. I talked to him a bunch of times over the last couple of days.
Yeah, I see him pop up everywhere. He's very well received and provides a lot of useful information. I don't really care for the name.
Big JR. Well, I'm tired of being confused. He gets a lot of credit for shit that I'm doing, and it's pissing me off.
Yeah, everybody. That's funny because that is true. No,
I know.
Yeah, I know. That's funny. I think he deserves the credit, not you. My opinion.
He's a good guy. He's a good guy. Super helpful to me over the last few days. I was bouncing all kinds of ideas off him. I think he is super helpful, notwithstanding the JR connection. Yeah, I mean, he needs to change his name. There can only be one JR.
There can only be. Any other questions? I'm leaving that to you.
No, I think we pretty much addressed everything.
All right. So, this was pretty informal. We just want to kind of go through the hearing of yesterday and, the events. Gina, just so you know, so after I left and we're driving and I get hold of JR and we talked afterwards. We could not stop laughing. It was at the time of the event, it was stunning. Really. I can't emphasize that. It was stunning, but afterwards, in retrospect, I thought it was really funny.
I honestly, I wish we wouldn't have connected on it. I wish we would have just avoided it, not talked to each other until we got on this space, because I could not. When you called me and the first words out of your mouth, once we both settled down, I literally giggled for like 5 minutes. I just could not stop laughing.
Yeah, you can guess whether I've been sending him kind of like suggested topics or titles.
There was all kinds of puns. So,
yes,
but wait,
there were a lot.
We got to make one comment here.
All right.
Big JR says it's actually Big Junior. You guys just can't read. Well, you know what, Big Junior? That's what I'm going to call you.
Nice.
Big Junior.
Nice. Big Junior from Cincinnati or Ohio, right?
I think he told us that once before, Big Junior.
Yeah, but we don't remember things very well. But he's from Ohio, I believe, right?
Yeah.
I think so. Yeah.
Dayton. I think he's from Dayton, Ohio, right? Big JR?
Oh.
No, I have no idea.
When I was in college, I don't know if you knew this or not, but when I was in college, I was Dayton too.
I'm familiar with Dayton, Ohio, because I spent a lot of time there when I was at the airline. So
oh, really? That's nice. You worked for what? You might as well disclose this. What airline did you work for?
For American Airlines. You can. You can. I have a. Here, I'll show you this one. This is my pride and joy. Because I started out at U.S. Airways. So we were U.S. Airways. I worked for American for 15 years.
Could you continue to move the screen? Because I'm not nauseous enough yet.
You want me to move it a little bit more? Shake it up and down? Smart ass. I worked for American for 15 years, but COVID, left because of COVID. So,
well, yeah. It's an interesting gig. Any other questions? We've been going about an hour and a half. So, and we've been talking about nothing.
We've been doing. Oh my gosh, we've been on an hour and a half. How many people are watching?
And we can talk about it privately. 17,243 is the count so far, and there's only 15,500 shareholders. I think we just established that there's shorts. That's what we just established.
There's borrows. There's borrows.
Anyway,
all right. I don't see any other questions.
Okay. Obviously, we'll. I'm expecting additional information documentation before the hearing next Friday. Obviously, if and when we get it, we will discuss it and let you guys know and at least give you our opinion of its significance. If not, then in some fashion, we will both be covering that particular hearing. Since I'm much closer to, even though the drive yesterday was very boring and took a long time, I'm very close to Nevada. So even though it's a pain in the butt, it's a minor pain in the butt. I know that JR is on the other side of the country, and that's pretty difficult. But one way or the other, we're both going to cover it, and we'll obviously, as we did yesterday and today, we'll let you know what goes on, and hopefully we'll have a positive. I'm hoping the judge rules next Friday, although it's possible he basically closes the hearing and then issues a ruling afterwards. Either way is fine. When he issued the order about the receiver, it took a few days after the hearing before he issued the initial order, and then something was prepared. So that's kind of how I see it. Anything to add, JR?
Nope. I think we can call it a night.
Okay. And again, thanks to everybody out there who watches this now or will watch it on replay. And again, since my Twitter got hacked, if you could follow me at not legal advice, one word. And JR, one more time. What's your Twitter handle?
Widener 2004.
At Widener 2004. And again, thanks for your support. Thanks for being here. And look forward to a positive outcome. Everybody be well, take care, and see you guys soon.
Yep. Take care. Bye.
Yeah. Really, when this thing's over. Come on. Doesn't want to go. It really doesn't.